Hey guys, Chris from Prep Logic. We're continuing our series on the Constitution and the Bill of Rights this week with the Third Amendment. The Third Amendment reads, "The housing of soldiers. No soldier shall be in time of peace quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." Now, largely the Third Amendment has really been a pretty secure amendment. There hasn't been a lot of challenges to it, save for a few. The most notable challenge to the Third Amendment came during the American Civil War, when federal troops crossing into the South would routinely garrison the homes of Southern widows, evicting them from their property and starving them, more or less. The problem comes in if the federal argument that the South was still part of the United States was to be held in validity, then the South should have been afforded the protections of the Constitution. Clearly they weren't. Now, moving forward to 2015, yes, there's pretty clear sailing for the Third Amendment. In 2015, a group of sovereign citizens took their case to the higher court and said that search warrants were a violation of their Third Amendment rights. The higher court very quickly shot this down for two reasons. One, officers aren't quartering in their home, and they're employees of the city, not the federal government or soldiers. And two, the service of a search warrant is congruent to your Fourth Amendment rights, and two amendments can't nullify each other. Sorry, sovereigns. Now, there was one particular case where case law was established that affected the Third Amendment in a positive way. In Ingbloom versus Carey, correctional officers have gone on strike and were evicted from their residences on the federal prison grounds. Note, these were federal prison employees. Now, while they were evicted, the federal government had someone come in to manage the prison. So they had state National Guardsmen come in and function as corrections officers while strike was being resolved. The COs, finding out that their previous residences were being occupied, filed a suit saying their Third Amendment rights were violated. So the U.S. Court of Appeals, Second Circuit, decided states' National Guardsmen were soldiers and serving as federal agents, and that the third applied to the status of them acting as federal agents and as soldiers, and that even though these homes weren't owned, the third goes beyond deedship to occupancy, or where a legal expectation of privacy exists. The majority held that the COs were covered by the third. However, Judge Erwin Kaufman maintained the officers were not leasing but employees, being provided with employee housing, so they weren't protected by the decision. The decision itself stood. That basically means that a person renting a property has the same protections as somebody who owns a property, which, believe it or not, by the letter of the law didn't exist before this case. So there's some positive change. I would say overall the Third Amendment is probably one of our more secure amendments so far. It hasn't enjoyed a lot of challenge. The challenges that it has enjoyed were historic, and we are kind of long separated from them. I think we should always be mindful of our past, but really it doesn't affect us at this point. If you have any questions or comments, please leave us a comment. If you like this content, smash that like button and be sure and subscribe. We've got lots more stuff coming. We're small, but we're growing. All we ask is that you're decent to each other, because we're all in this together. God bless.